Hello, everybody. Welcome. Today's webinar is Strata Living in British Columbia Town Hall Edition. We have two amazing speakers, Lisa Mackey and Tony Giaventu. I'll introduce them in just a few minutes. My name is Paula Price. I'm with the People's Law School, and I will be our host and moderator for today's webinar. What you can expect today are answers to your questions. What you will receive is legal information, not advice. So if what you're looking for is legal advice, which is the law as it applies to your specific set of circumstances, then we recommend that you reach out to one of our speakers. You can reach out to a lawyer. The information that we're sharing, and the information, of course, for our speakers is on the screen. The information that we're sharing is current as of today, February 24th, 2022. We'd like to acknowledge that the land on which the People's Law School team is gathered is the unceded territory of the Coast Salish peoples, including the Musqueam First Nation, the Squamish Nation, and the Tsleil-Waututh Nation. We'd also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation of British Columbia, whose funding makes the production of today's webinar possible. And finally, we would also like to thank and welcome our speakers, Lisa Mackey and Tony Giaventu. So I'm going to start by introducing Tony. For those of you who do not know Tony Giaventu, he is the Executive Director of the Condominium Homeowners Association of British Columbia. And Tony is also the writer of a column called Condo Smarts. And it is a column that I understand he has been writing since 2002. So we're now at the 20-year anniversary. He tells me that in April, he'll be publishing the 1000th, the 1000th article. So Tony, here you are. Welcome. It's so great to have you here today.
Thanks so much, Paula. It's a pleasure to be participating.
We're so happy to have you. And we'd also like to introduce our other speaker, Lisa Mackey. Lisa Mackey is a partner at Alexander, Holborn, Bowden & Lang, which is a law firm based in downtown Vancouver. She is the leader of the firm's Strata Property Practice Group. And we are so delighted to have Lisa here. Lisa is also a regular speaker and writer. She has taught at the Vancouver Community College. She has spoken for a number of organizations, including for CHOA. She has been featured in the CBC News, CBC Radio, and other media. And she was recently featured on Tony's weekly article, Condo Smarts. And so we are delighted to have Lisa here today to join us. Thank you so much for being here, Lisa.
Thanks so much for inviting me, Paula.
Thank you so much. So we are in very good hands today. And so with that, we are going to jump into our questions. As I mentioned, all of these questions came from you, people who have signed up to today's webinar. And the first question is, can the strata restrict the number of occupants in a unit?
This is a great question, Paula, and it makes sense actually over the last couple of years where we've all been sort of cooped up beside one another, and maybe we have concerns about the number of occupants living next door. The short answer to this question is yes. The longer lawyerly answer is it's complicated. So for starters, stratas can regulate their community by way of bylaws and rules. In this case, if a strata wants to restrict the number of occupants inside a strata lot, we would be looking at a bylaw. There is an obligation on strata corporations to enforce the bylaws, but there's also a recognition of discretion. And we also have some other laws out there that provide exceptions to the rules as well, like the Human Rights Code. So when we talk about restricting the number of occupants for a unit, yes, the strata can pass a bylaw that says perhaps no more than 2 persons can occupy a 1-bedroom suite, but there needs to be some exercise of discretion there. Under our human rights legislation, we have protections for things like family status. So if somebody is in a relationship and they have a baby and they're in violation of the Strata's occupancy restriction, there might be a need for the Strata Council to flex that bylaw and accommodate the family under the community. So there's a lot of other considerations when it comes to occupancy restrictions that councils and communities should keep in mind. And Tony, have you encountered a lot of occupancy restrictions in your day-to-day discussions with owners?
Well, it's becoming more predominant, and
Yeah.
strangely enough, it relates to short-term accommodations.
Yeah.
And so where we have Airbnb and there are no restrictions, a 1 or 2 bedroom unit suddenly have 8 people staying in it for 3 days. And it places a significant amount of pressure on the resources of the building, but it also creates security problems because there are not sufficient access keys or fobs. It usually results in noise complaints. There are often additional cars that are associated with it. So the occupancy issue becomes more complicated when you start taking short-term accommodations into consideration as well. We often tell people, if you're looking at this, start at the source of what your occupancy was intended for. Go to your zoning, to your city, what was intended for occupancy for the units, and you'll frequently find that 1 bedroom units have an occupancy limit of 3 or 4, 2 bedroom units maybe 5 or 6, and it'll give you some comparative numbers that you can use as reference as well of what they're for. One other thing about it is look at also the size of the unit. A 1 bedroom unit that is designed cleverly, that's 900 square feet, is quite easy to accommodate 3 or 4 people. A 1 bedroom unit that's 565 square feet can barely accommodate 2 munchkins, right? So, you know, like we're really looking at size does matter when it comes to occupancy and the number of people within units.
Beautiful. Thank you, both of you. We have another question about the usage of a unit here. What happens in the situation? This question is for you, Tony. If my husband passes away, am I allowed to rent out our second bedroom to somebody for income?
Well, rentals are regulated by rental bylaws of the Strata Corporation. So it depends on what the rental bylaw actually sets out. The Act actually refers to bylaws that apply to the rental of a strata lot or portion of a strata lot. So it really goes to the heart of how extensive is our rental bylaw, and does it extend into that? And we always start with looking at the bylaws. They're going to have the most significant impact on what the decision here might be. Notwithstanding that, we might have exemptions. This could be a family member that's living with the owner. It could be a hardship circumstance where, in order to be able to continue to survive and pay the bills, they're going to have to rent out a room and have a roommate. There may be a number of other circumstances, or this might be an original owner under a rental disclosure, in which case the rental bylaw wouldn't apply anyhow. So you really need to look closely at the bylaws and the conditions that apply.
Super. Thank you so much.
I was going to say, Lisa, I can't think of this being a human rights condition. This is more about occupancy and tenancy here.
Yeah, the Human Rights Code doesn't protect persons based on their financial status. So if somebody says that they're encountering financial hardship and they need to rent out a separate bedroom, then the Human Rights Code wouldn't come into play there. If it was a different scenario that they needed a live-in caretaker to come in with them and provide medical treatment, for example, or assistance, then we're starting to look at the protections that the code offers. But I agree with you. We're looking straight at hardship under the Strata Property Act and looking at your bylaws, which is really important to do.
Beautiful. Thank you both. This next question is for you, Tony, and it is, what kind of alterations need approval from the strata? And there's a second part to the question, which is, if your neighbor is undertaking renovations, how can you protect yourself against their proposed renovations?
Well, the standard bylaws will set out conditions for alterations. So alterations to the structure of the strata lot, or anything that the Strata Corporation is obliged to ensure, which are original fixtures. those technically need the approval of the Strata Corporation through the council, and the council can't be unreasonable about this. However, we often see this is the creeping intention here. Someone says, we're going to do some basic redecorating of our unit, and then you discover that they've ripped out all the kitchen cabinets and the bathtub and everything, and they're reinstalling plumbing, and they've relocated the kitchen sink, and a number of alterations are done without building permits, not to code. They frequently result in damages to the building. A wall may be removed that could be structural. So I think what's really important more than anything is that a written communication is established between the person making the application and the Strata Council. So they clearly understand what alterations are taking place. Small alterations may have a significant impact to everyone else in the building. And you know, it's the hardwood floor is a good example. We live in a wood frame building, so wood frame buildings are already susceptible to noise. Simple things like closets, doors closing, a washing machine on, you can still hear them. That happens in wood frame buildings. When you convert carpeting, which was intended as part of the sound suppression, to hardwood flooring, the hardwood flooring suddenly radiates so much more sound, and all the sound suppression and soundproofing in the world underneath it doesn't eliminate the fact that the impact on the hardwood flooring is now 5 to 10 times greater than it would have been on carpeting. So, you know, everything you need to look at, is it going to change the structure? Are any of the services going to be changed? Will this change the air circulation in the building? Any of the fire safety equipment? Does it have an impact on neighbors? Does it have sound changes that may affect it? Are there any structural changes? It's a pretty long shopping list. So my impression generally is, before you do any alterations, always go to your Strata Council for approval. Most things that are minor cosmetics, such as painting, doing simple upgrades, Strata Councils have no issues with those. But when you start getting into more mechanical, technical issues, they have a long impact.
Beautiful. And a quick question there, Tony. I believe one of the questions was about appliances. So where do they fit between the cosmetics and the structural? Are they still in the area of where you wouldn't need Strata approval, or does it depend on the bylaws?
Appliances that are not built in, that can be removed or replaced. So that's pretty much all of our fridges, our stoves, etc. They're not a fixture of the corporation. They're an asset of the owner, and they're the responsibility of the owner. It's up to the owner to replace them on whatever cycle or basis they are. But here's a complaint that occurs frequently, and Lisa, I know that you've dealt with this. Someone decides to upgrade their fridge. So the refrigerator is removed. They've installed a new fridge with an ice maker that now requires a water line. So a plumbing alteration has to be done. It gets installed, doesn't get installed properly, or it's a do-it-yourself at home job. And over a period of time, we have a slow leak that causes a significant amount of damage to the building. Those are the kind of things, as a neighbor, I need to be aware of, because those are the types of impacts that really affect our use. So, you know, it's not simply a matter of reinstalling an appliance. If it's the same fridge basically that you're putting in that you've taken out, that's not something that requires approval. But when you're looking at alterations to the services, that's where approval really comes in. And I know, Lisa, from an insurance perspective, these can be really costly claims, and they're not covered by insurance claims if it's been a long-term failure.
No, that's right. And I agree with you, Tony. When in doubt, ask your counsel for information. It is about information sharing. If it looks like you're doing more than just plugging in the new appliance, you need to modify other areas of your property to make it work, then chances are, yes, you need special approval, and the council might set conditions on that. I know in the summer, when we had that heat wave, the installation of air conditioners was a big trend in our province, and a lot of folks didn't realize if they needed council approval for that, and there can be insurance implications, as Tony mentioned, in the event of property damage arising from the new appliance that's supposed to make your life easier. So.
Beautiful. Thank you. And I love where this conversation is going, because Lisa, the next question is for you, and it is about water damage. So if there's a common property inside the walls and it leaks into a unit, who's responsible for the repair? Is it the owner or is it the strata?
Yeah, and that's a great question, and we get that a lot at our office as well. When it rains, it pours, right? And when it's a pipe burst, it can cause a lot of damage to the common property as well as to other strata lots. Every time I hear about a pipe burst, my second word that pops into mind is insurance. And so, depending on the scope of the damage, the first call that the council would want to make is to the Strata Corporation's insurance provider and see whether or not there's coverage available to attend to the water damage. Responsibility is an interesting word, and it will all depend on what caused the pipe to burst in the first place. We look to the bylaws to see accountability for who's responsible for repairing what. Typically, the bylaws will say that the Strata Corporation is responsible just for the common property and common property pipe repairs, and owners are responsible for their strata lot. And so unless an owner can demonstrate that that Strata Corporation fell below their maintenance standard, they stayed on top of their pipe inspections and repairs, it would be hard pressed to blame the strata to have to repair the inside of their unit unless there was some misstep on the strata's part. But usually what I like to see is an evaluation of whether there's insurance available. Why pay out of pocket when the whole point of the insurance coverage is there to protect you?
Beautiful. Thank you. And this next question is one that I think also comes up quite often, which is one about smoking, right? What are your rights as a unit holder? Excuse me, if your neighbor is smoking cigarettes or smoking marijuana outside and it's drifting in through your windows, and sometimes I guess it can even come in through the walls. So, Tony, what would you recommend in this situation?
Well, I would expand this definition to smoking barbecues, to incense burning, any type of substance that may be combustible that invades the space and the use of another person is a nuisance. So you don't actually need a bylaw to combat this problem as an amendment, because we already have a nuisance bylaw built into the standard bylaws. This not only is this an issue with respect to lifestyle, but this is frequently a health hazard to the other people who are exposed to it. And so it's the duty of the corporation to really to make sure that they enforce these bylaws. Smoke-Free BC have a great website, and they have a great navigation place of all of the buildings who have now adopted smoke-free environments in their buildings. So strata corporations can adopt bylaws that prohibit the consumption of products that are through a combustible form, smoking marijuana, cigarettes, whatever it may be. They often extend that to things like barbecues on balconies. As you go through this, you'll find that different types of buildings and different types of building systems can manage them better. But one of the other issues that we often associate with the smoking problem is that these strata corporations that are in apartment style buildings, high rises, low rise, generally have a makeup air unit on their rooftop. That makeup air unit creates pressurization of air blowing through the corridors, which keeps basically positive pressure on all of the units. That prevents carbon monoxide from exhausting from vehicles up through elevator shafts from parking garages, and it helps to reduce smoke associated with smoking or cooking odors, or in the worst case scenario, smoke from a fire in a unit from contaminating other units. Those systems are frequently not operating at their efficient levels. They're frequently turned down or they're turned off. Strata corporations think that there are cost savings in turning them down at night. There are none. It will just simply increase the wear and tear and the maintenance factor on the building. It does not solve the problem for you. This constant air circulation also helps to reduce the risk of mold and mildew buildup within buildings. By eliminating your makeup air systems, it creates a bigger problem. I think, Lisa and I've talked about this in the past a few times. Every time a strata corporation adopts a bylaw that prohibits smoke, you always have someone who says, I'm an addicted smoker. It's a human rights situation. I need to be exempted. I need to be grandfathered from this bylaw. Well, they could be potentially accommodated, but they don't get to be exempted from creating a nuisance for everyone else. And that's where this line really gets drawn for everybody else who has to be exposed to it within the building systems. I don't have to live with somebody else's smoking byproducts. And, you know, I don't know, Lisa, the test from the human rights side is really quite interesting when it deals with this issue.
It is, and it's a very high threshold. So somebody who's saying they have a right to smoke or a medical need to smoke, whether it's marijuana or nicotine addiction, they need to demonstrate that that they need to smoke in the current manner that they're smoking in order to manage their addiction or their disability. It is to the point of undue hardship. So it's a high standard to meet in order for a strata corporation to accommodate someone. But there is that balancing act, as Tony said, and typically the accommodation will not warrant a nuisance or a health hazard to others.
Beautiful. Thank you both so much. So great to know, because I know that's an issue that comes up often. Thank you. This next question is for you, Lisa. And if your strata council refuses to comply with the Strata Property Act, is the only solution to go to the Civil Resolution Tribunal?
Yeah, and the CRT for short has been very, very busy since it opened its doors a few years ago. And it might feel like that's the only resolution available. Now, the Strata Property Act and the standard bylaws have a lot of options for owners that are struggling with their strata council. So there's arbitration available under the Strata Property Act, although it's really not used as much now. The Civil Resolution Tribunal is designed to be a more efficient process. It's online, it's more accessible, it's certainly less expensive than going to court, which was the usual venue for strata disputes, the Supreme Court. But I also remind folks that the Civil Resolution Tribunal is presided by a stranger who doesn't know your community as well as you do. So when there's always an opportunity to work with your council, to educate your council, and to work together as an ownership to potentially resolution change, which you can do under the Strata Property Act. I always like crafting my solution by my own hand first. So is the CRT the only solution? The answer is no. Is it sometimes the place we go for remedy? Absolutely. But Tony, I know that over the last year in particular, the CRT has been inundated with a lot of disputes, and the result or the remedy at the end of the day might not fix the problem.
No, and you know, the other problem with or challenge for the CRT is they have limited scope of authority here.
Mm-hmm.
So, you know, the expectation is our council isn't complying with the act. Can you dismiss our council? No, they can't, right? And so that's one of the challenges that exists here. But the other solution sometimes, which practically works, start talking to all of your owners. If this is genuinely an issue and a problem, might be time to actually petition for a special general meeting and get rid of this strata council. And it could be not the whole council. It could be one council member who is really acting aggressively and bullying everyone, and they are just, you know, being submissive to them to avoid conflict. That might be the source of the problem. And oftentimes it's an individual that is the source of this problem, not the entire strata council. So you know, look closely at the leadership situation. When you're in a situation that becomes a strata council that refuses to comply with the act, my experience has been they also refuse to comply with orders from the CRT. So, you know, it doesn't necessarily solve the problem.
Yeah, thank you so much, both of you, Tony and Lisa. I think that's some really helpful ideas of what you might do other than going straight to the Civil Resolution Tribunal. This next question is for you, Lisa. And what happens if a strata property manager doesn't follow a bylaw and gives a particular resident special treatment? And the questions here are, would the current strata council be at fault if the property manager went behind their backs? And how can the strata prepare itself for a possible lawsuit from the resident?
Yeah, and this is a challenge, and we need to sort of understand what is a strata property manager relative to the strata council. So a property manager is the agent of the strata corporation. They follow instructions and directions of the strata council. The strata council is the body that's tasked with bylaw enforcement. So it would be the council determining whether or not there's been a bylaw breach, and if so, what the appropriate remedy would be, whether it's a fine or some other option under the act. If it looks like somebody is being inordinately exempted from a bylaw or receiving special treatment from the property manager, then the question in my mind is that at the direction of council? And the follow-up question here, if the council was unaware and the property manager went behind their back, well, then that's an issue between council and management and whether or not there needs to be a new manager in place. Because as I mentioned, they're simply an agent of the council. They are supposed to follow the directions of council, and they shouldn't be acting unilaterally, and certainly in a way that puts the Strata Council in a compromising position, or at the last question on your slide here, at the possible risk of a claim, whether that's at the CRT or some other forum.
Beautiful. Thank
Yeah,
you.
and you know, the other side of that, make sure that your Strata Council, every council member has a copy of your service agreement. So they
Yeah.
understand clearly the authority and the responsibilities that your manager has. And if you have problems with that as your Strata Council, speak to the broker of the management company and deal with them directly. It's in their interest to solve this problem, and it might be time for a change of a manager.
That's really helpful. Thank you both. This next question is for you, Tony, and it's about fines. So I'll read the question here. In this case, Strata Council levied fines against a unit based on false allegations. The unit owner says, I've attended a hearing disputing the allegations, and council agreed not to charge any more fines, but they won't remove them until ADR occurs. Yet the complainants have moved. That option is not available. So the last fine was issued in 2018. Under the Limitations Act, does council have 2 years to take action, or should the fines be removed?
So I'm going to reframe this into a different perspective. And really what this is about is what type of evidence or information can a Strata Council rely on for the enforcement of bylaws? Because really, if they end up in a CRT dispute or a Supreme Court dispute, if it's that much larger, they're really going to be in a situation where that evidence that they relied upon is going to be scrutinized. They, you know, who complained, when did they complain, what did they complain about? The particulars of the complaint have to be identified. And so it's really up to the Strata Council themselves to establish whether the evidence is credible. In the situation, if it does appear that the allegations or the evidence that they've been given is questionable, then Strata Council needs to step back and say, it is questionable. Well, you know, we've investigated it. Thank you very much for your complaint. At this time, we don't have sufficient evidence to be able to pursue this any further. You send a reminder to the other owner of the other parties of what the potential issues are, and it may come back again if more evidence presents itself. But one of the challenges for Strata Councils is that they see a fine that exists on a file from 2019 or 2020 that hasn't been collected yet. There's no evidence in the records. There's nothing in the minutes of the meetings. There's no decision in the minutes of the meetings as to how they got to this. Does the Strata Council have the ability to reverse or remove those fines? Absolutely. They're not a common expense. They're not an authorized expense as a special levy or as an annual budget item. They were a penalty for an alleged allegation. And if you don't have supporting documentation to be able to deal with this, especially within the limitation period, you're probably in your best interest to remove them and to reverse them out of your receivables. You might never collect them anyhow. I don't know, Lisa, it's, you know, this is a real, it's a real stumbling block for Strata Councils, because you get a new Strata Council on board, property manager gives them a list of receivables that shows $13,000 in fines that they might probably never collect.
Yeah, and it's become more and more of a stumbling block because the CRT has issued their thoughts on whether or not the Limitation Act actually applies to fines. And according to CRT, it doesn't. So it leads to what Tony's been saying, is that we have all of these stale fines on the account. We don't have any context to why they're there. We don't have any evidence. And so the longer you wait, regardless of whether or not that limitation period applied, and the CRT is saying it doesn't, regardless of how long you wait, the evidence depreciation will impact your ability to collect at the end of the day. So if your Strata Council isn't diligently collecting on the fines, then it's going to be that much tougher for councils down the line to be able to understand why they're there and to be able to collect them for the community.
I think the other message is here, don't wait. 2018, that's ridiculous. That's 4 years ago. But let's just convert this into damages. someone had their barbecue in a townhouse too close to the building, caused $1,800 of damages to the siding that had to be replaced. So it sits there. The Strata Corporation has this expectation that if the owner sells, which evolutionary wise, it ends up happening, we'll just collect it when it sells. Well, insurance deductible and damages can't be included on a Form F payment for certificate for collections unless you have a judgment for them. So don't wait. Within 3 to 6 months, make a decision on how you're going to collect these.
Thank you so much, both of you. This next question is for you, Tony, and this is a situation where we have a small self-run complex where they don't know quite how to do it properly, but they do enough to keep things running. And what happens if they're not in compliance with the Strata Property Act?
Ooh, this is my biggest pet peeve. And it's where I look at real estate listings and it says the words non-conforming strata. There's no such thing as a non-conforming strata. They're all strata corporations, all 32,000 of them across the province, from duplexes up to 1,100 units. They may be a strata corporation that might not be complying with the act in its entirety. They might have comfortable agreements amongst in a duplex or a fourplex amongst the owners, where they just simply cut checks as they need them. The complications arise when there are real estate transactions, though. Where do you find records? Where do you find financial documents? Somebody needs a mortgage. The bank or the lender is going to be asking for records and documents in order to facilitate the mortgage. Copy the annual budget, the financial statements, minutes of meetings. Depending on how much you're asking for funding wise in relationship to the debt load for your mortgage, you might not be able to provide those documents in a smaller strata. So, a self-run small complex, and by the way, the largest self-run strata in the province is 600 units, and they do an amazing job. So it isn't about whether you have a manager or not, it's about, do you have an organizational structure that can really deal with your building and your property? On our website, we have a guide called the Basics of Strata Operations. It's basically an 8-page guide that gives you the basics of how to run your strata to meet the minimum requirements of the Strata Property Act. I'd recommend people look at it because it really does give you a checklist. What are the basic things we need to know? More than anything, though, make sure you create a bank account and that you apportion your common expenses, such as insurance and general maintenance, through that bank account, so that you have some records to identify the history and the function of your strata corporation. I don't know, Lisa. I don't know how people are doing transactions for strata corporations that are self-run, but they have no records to produce.
Yeah, and it's difficult. And the question, what happens if we're not following the Strata Property Act? And it's all well and good when your community gets along and your existing owners are okay with how it's being run, regardless of whether or not it's compliant with the act. But when we have new ownership and turnover, then we get problems, because there might be a different expectation that this is not a non-conforming strata. We do need to comply with the Strata Property Act, and there's minimal expectations for that, like financial management, repair and maintenance, etc. And so it really depends on the membership in your community, which is open to change. And I think that's one of the things to keep in mind too in your strata communities, is that depending on who's on your strata council, depending on who are your neighbors, your experience in your strata can be very different from year to year.
Yeah, so true. Thank you both. That's such a great response to that question. And I know in our neighborhood, there's a lot of duplexes that I think fall under that category of non-compliant stratas. So our next question is for you, Lisa, this question about bylaws. So in this case, we have really old bylaws. We want to completely redo them with legal and owner approval. And so the question here is, can they completely scrap the old bylaws and start fresh with the standard bylaws with revisions, or do they need to go piece by piece and change, delete, add each bylaw individually?
So this is actually a good segue from what we talked about with the change in ownership and the fact that the strata can be changing from year to year. Your bylaws can change as well. And so some strata corporations will like to go by way of bylaw amendments or additions every year. Others will want a full review and replacement. I'm a big fan of doing annual reviews just to make sure that your bylaws are still compliant with the Strata Property Act and other laws that have changed over the last year. But more importantly, that they meet the current needs of your community. So often bylaws are drafted and changed because there's been an issue that's cropped up in your community that you needed to address. I like the full replacement and amendment option when we are doing a larger scale update, and 1 or 2 bylaw amendments wouldn't be what we're looking for here. Either way, we want to make sure that we craft our appropriate resolution for the meeting, that we get that 3/4 vote, that we give people notice of that meeting. It's all well and good when we want to change the bylaws, but we want to make sure that we follow the steps to do that as well. And then not forgetting the final step either about registering the bylaw amendment or the new set of bylaws with the Land Title Office. If you forget to register your bylaws, well, then you can forget bylaw enforcement because those bylaws will not be enforceable. So really important for councils to keep that in mind too.
Beautiful. Thank you, Lisa. Now, I just wanted to point out
I'm going to jump in though, Paula,
Sure.
because Lisa and I have dealt with this recently. We often see at Strata Council meetings consolidated bylaws for convenience use, and they're distributed to the owners. So somebody's taken 5 or 10 sets of bylaws and melted them all together into one set. It's disastrous. There's almost always something that is not enforceable, has never been filed, or contradicts something else. Avoid doing that. If you want a new set of consolidated bylaws, put them together, pass them at a meeting, and get them registered so that you know they're all enforceable and all in effect.
Fabulous. Fabulous. So I just want to say we've got 4 more questions, then we're turning to the live questions, and I see we have about 64. I don't have them open. Of the live Q&A. So we'll move through these questions and then try to keep some time open for those questions. This next one then is, is for you, Tony. Can a spouse who's not registered on title be considered a tenant and therefore eligible for Strata Council?
So that is always challenged and always tested. If they're not on title and they're living with their spouse, they're a spouse. They're not in a tenancy agreement, not in a tenancy arrangement. You can't reinvent the occupancy or status of occupancy. If you want your spouse to be on council and they're not on title, then get your Strata Corporation to amend their bylaws to permit this. But there's often a very good reason why the spouse is not on title. It may be because they are a professional in another industry and they are protecting their personal assets from any challenges. So you have an individual who now could be on council who may not have any interest in the property. Is that a wise decision? Many Strata corporations have amended their bylaws to permit a spouse who is not on title to be on council. I think we haven't had a decision on this, so it's kind of difficult to take it to the end. But really, does it constitute a tenancy under the Residential Tenancy Act? What it constitutes is a domestic dispute that ends up in family court. That's a whole other discussion. And then you end up with 2 owners at a registration table fighting over who has voting rights at an annual meeting. It becomes much more of a complicated issue. I don't know, Lisa. I don't think there's any way around this. This really isn't a tenancy. It's a spousal occupation.
No, and I've certainly not heard of a scenario where someone can prove a tenancy when they're in a spousal relationship. There might be an argument to say, well, my spouse pays me monthly rent, therefore they're my tenant. Worst landlord ever. But Tony's right. It's a completely different relationship. That's not to say you can't amend your bylaws and allow spouses of owners on title to be eligible for council. So I think I would look there if you're looking to expand the eligibility.
Beautiful. Thank you so much. This next question is for you, Lisa. Do Strata members have the right to see the correspondence between Strata Council and businesses, especially if you're in a situation where there's questions about whether council made an honest effort to seek out the lowest bid?
Yeah, this is a great question. And often I think there's a misconception that correspondence means a letter, and it doesn't necessarily mean an email or some other more convenient ways that we can discuss. So under the Strata Property Act, correspondence that is exchanged, that's sent, received from Strata Council, Strata Corporation, is a record that needs to be kept by the Strata. It's open for request and access by ownership. And that's if it's sent by a text message, frankly, or by an email, that information is accessible to the ownership. And there's good reason for that. And the Strata Property Act is meant to highlight democratic governance, but also transparent governance as well. So owners do have a right to that exchange. I do give a caveat to our council clients that whatever you say can and will be used against you at the CRT. So be very, very careful as to what you commit in an email that you think might have been a casual exchange. Be very, very mindful that these are records of the Strata Corporation, records of your community. And Tony, I know that you receive a lot of questions as well from owners about Strata councils that have kept this type of communication under lock and key.
Well, yeah, and we have to put this into some proportion. This isn't going to be a $1,500 gutter cleaning question.
Yeah.
This really comes down to a $15 million repair to a high-rise building. And the question is, can we manage this information in a way that protects the proprietary interests of the bidders so that they're not compromised for unfair competition? Because that's often the source of this. Somebody wants to see the bids between the parties. It's not because they're interested as to whether the Strata bid this or not, but they're actually probably acting for one of the parties who's trying to find inside information. And it's a complaint that often comes up. I think Strata councils can avoid this problem by having blind information to their owners. We received 4 bids. Here's the information of the bids. We're simply not going to identify who the companies are to protect their proprietary interests. Summaries can be very helpful. One of the wonderful things that's happened with Zoom and all the meetings we've done in the last 2 years, we just see a huge increase on general information meetings to be able to talk about projects. And it's made a significant difference to the comfort level within Strata communities about how business is actually being conducted.
Super. Thank you so much. So we've got 2 more questions, and then we're going to turn to live. And I'm just noting the time. We've got just about 15 minutes left. So we'll go through these 2 questions, and then we'll open up the live Q&A. So this next question is for you, Tony. In this situation, we have an owner in a strata who consistently holds more than 30 proxies during a general meeting. Is there any way to limit the number of proxies per owner or otherwise address the situation?
So 2 parts to this. The first is you cannot limit the number of proxies because there's no way to enforce this bylaw. Bylaw enforcement requires notice of complaint, etc. And what you don't want is you don't want a bylaw that basically takes the chair of the meeting or the registrar at the meeting and puts them into a compromising situation about who is going to be an eligible voter or not. This ultimately will determine, if you did this, parties that would not be eligible voters, and the Act makes no provision for this. So no, you can't limit the number of proxies, but there is a strategy that you can use that actually reduces this frequently. If you have an individual who's using these proxies inappropriately, which is the real problem that owners are raising when they ask this question. And this comes down to your bylaws about how votes are taken. You'll find that people who are holding a lot of proxies, if their intentions are really not in the interest of the Strata Corporation, what they'll do is they'll request a secret ballot when it comes to a controversial issue, because they're going to only vote in their own interest, and they're often there simply to just defeat resolutions and special levies. If you can alter or amend your bylaws to remove the secret ballot function, and when you have votes that are critical, call the roll, unit by unit, whether it's in person or by proxy, how do you vote, and record that in the minutes. And what it will do is it will stop individuals from holding too many proxies, or if they are holding proxies, it will essentially force them to vote in accordance with the instructions they've been given.
Super, thank you. It's a very practical strategy. And then this last question is for you, Lisa. In this case, we have a 40-year-old townhouse style strata. It needs extensive rehab to the building exterior. So here they talk about new windows, skylights, and decks, and a large special levy is imminent. So they've got 50 strata lot owners. They've always paid their fees in relation to a particular unit entitlement. Now the council president says that they want to redistribute that, create another formula. Can that be done? And if so, how?
Yeah, and so by default, the special levies are usually funded by unit entitlement. And so if we want to deviate from that, the Strata Property Act allows us to. We have a tool, it's called a unanimous vote. Now, it's a very, very difficult tool to use because unanimous means unanimous, and it means all eligible voters, and that could include mortgagees as well. And so it's a very, very high hurdle to change the formula from unit entitlement. That's not to say that it can ever be done, but a unanimous vote is literally the toughest vote to pass under a Strata Property Act.
Beautiful. And I've just opened into the Q&A, and I'm trying to see which ones have the most popular votes. So first one we have is, how do we deal with conflicts within council where a member uses strata resources for personal benefit?
Oh, goodness.
Oh, that never happens.
I was going to say that always happens. No.
I was being generous. So a good example would be a strata in Coquitlam a few months ago, where the owners have discovered that there were renovations being done to the building. There was a balcony repair and whatnot, but the council member also had new hardwood floors at the expense of the strata put into their unit, right? And so how do you deal with that? It may require a general meeting. It definitely is going to require some legal advice as to what to do. And if it was an unlawful use of the funds with respects to their personal use or their strata lot, it may require compensation or an application to the tribunal or the courts. It's a difficult thing to prove sometimes. Another scenario that came up recently in a strata corporation, and I have a copy of the notice that was issued to the owners from the president of council and the property manager that says, if you wish to purchase an additional parking space, we have 8 parking spaces available in common property. Well, you can't sell common property for starters. The owners have not voted by 3/4 vote to create any kind of leases associated with this or a subdivision of property. So here you have an activity that's taking place that's both unlawful and no accountability as to how the transactions are occurring. So these do occur frequently, and strata councils struggle with them. And Lisa, I know we've spoken to a number of strata corporations where this occurs.
Yeah, and potentially it's the Strata Council should seek legal advice. Is there a possible claim over as against the individual council member? Council members are volunteers, but we also carry a lot of weight with that volunteering, which is a duty to act in good faith, a duty to act in the best interest of the Strata Corporation, and to follow the bylaws. And certainly funding your own personal renovations with Strata funds will not qualify.
Doesn't count. Beautiful, thank you. I'm going to ask another question that had a number of votes. Turnover of documents. How do you deal with an outgoing strata council who have not turned over official strata documents such as correspondence with owners, etc., to an incoming council?
Well, the records belong to the Strata Corporation. They do not belong to a Strata Council. And so if a Strata Council, an old Strata Council member is holding on to records that should be properly within the Strata Corporation, then potentially there's a need to intervene and obtain a remedy where you can essentially force that transition or force that individual to provide a copy of the records to the Strata Corporation. The issue that I've seen is where Strata Council members have used their own personal email accounts and they necessarily haven't been stored properly with the Strata Corporation. Those are still records of the Strata, so they do need to be turned over if it has anything to do with Strata Council business or decisions made. But yeah, I mean, older former Strata Council members, you are a former, you are not a representative of the Strata Corporation, and those records do not belong to you.
And set up a website. There are a number of companies out there who do a great service of hosting information for strata corporations at a nominal cost. create a website, get all of your records and documents onto the website. Other than confidential or personal information of owners, pretty much everything is accessible anyhow, and it really helps to facilitate communication within your strata. Your owners should have access to the records as well. There's no reason, unless you're dealing with personal information, there's really no reason not to have accessibility to these records, and it stops this problem.
Thank you both so much. Here's another question which kind of follows up on one of our earlier questions. Here's the question. Neighbors upstairs installed new wood floors, not laminate, raised wood floor. Now the noise is amplified. Is there anything we can do now?
Yes, if the answer was no, this would be a very, very short discussion. there's nothing you can do. You can typeset move. Yes, so a couple of things. So one is, was that an alteration done with council approval? Were there certain standards that were met or not met under the bylaws for hard surface flooring? So have a look at the bylaws there. Potentially there might be a need for an acoustical engineer to have a look and see if there's actually been an impact on the noise transference between floors. The Strata Corporation does need to get involved with that. I see a lot of discord when councils don't want to get involved and feel like it's an owner issue, but it's certainly something that the council should take seriously and investigate to see whether or not there has been a compromise to the building. So yes, there is recourse there.
Well, and the other side of this is the consumers are really at the mercy of the commercial companies who are selling flooring, because they try to convince everyone that we can put in sound suppression underneath the floors so that this isn't a problem for the neighbors. That's not the solution, because the problem is not the sound suppression. The problem is you've gone from a soft surface that absorbs sound to a hard surface that radiates sound. So you've moved from, drop a marble on a pillow and what do you hear? Virtually nothing. Drop a marble on the face of a guitar and you hear quite an enormous level of sound that will radiate. And that's exactly the difference. And so the problem here is that the building was never probably designed for hard surface flooring when it comes to acoustic management. It was designed for carpets to absorb sound. So now we've changed the dynamics of the acoustic management in the building. And you know, I really am quite critical of organizations that sell flooring who try to convince people that they won't have a problem because we can put in sound barriers and sound suppression.
This question has a number of upvotes, and it follows on one of the questions we had earlier. If a baby is born to a couple in a 19+ unit, can we use discretion to allow it?
Yes, there's always discretion with bylaw enforcement, and that's a message that I keep repeating to our strata councils that we assist. There is always discretion and flexibility. When we're talking about baby, we're talking about family status, we're talking about human rights. These are very, very complicated questions, and it's not as cut and dry as I need to enforce the bylaw and it's appropriate to enforce it with this particular remedy. Discretion should be one of the go-to maneuvers with bylaw enforcement. There has to be an exercise of discretion.
Fabulous. And Tony, did you have anything that you wanted to add?
No.
Okay, I see one more question, and we have just a couple minutes. So many great questions, everybody. Can you talk on age restrictions? I was under the impression the only legally enforceable was age 55+. Is that still correct?
No, the act itself was modified with a type of notwithstanding clause with respects to the Human Rights Code. So it's more than just about age. It's about occupancy from a variety of conditions. So, you know, the real first question that you're asking yourself is, are we a building that is a family-oriented building, or are we a building that's more of an adult building? And sometimes that can be determined by geography. It can be determined by the design of the building. But the other side of it is, are we a retirement community as well? And that age level can be set at a number of standards. Could be 35 and over, 55 and over. The challenge is, and I think this is what really strata councils need to be going back and doing, what are you expecting is going to happen from this bylaw? because the anticipation here is that we're going to be just seniors over 55. We actually now have a number of buildings who started 20 years ago with 55 and over bylaws that are now repealing them because they've come to the problem that everyone is aged substantially. No one wants to be on strata council anymore, and their communities are really struggling. So they really do want to have families, and they do want to have engagement communities back. So, you know, fear for what you want, because you might just get it with your bylaw amendments, but there are consequences that come with it on the backside. Lisa, how does the residential tenancy implication work with age restriction bylaws?
Well, it's interesting. So the Residential Tenancy Act says that you can contract with a minor. So it's one of the exceptions to the rule that you can enter into a contract with someone who's not 19 years of age or older, and it's legally enforceable. So from the Act's perspective, you can strike a deal with a 5-year-old. Would I want to? Probably not. but there's definitely more room and flexibility there. I think Tony's tip of what is your goal with your bylaw? What are you trying to address is something that speaks to the age bylaw, but also speaks to every bylaw. What goal do I have? Will I achieve that goal with this particular bylaw amendment?
Super, thank you. And I'm just wondering, we're at 1 o'clock, but there's a question here that I was wondering if I can put to you. Do you have a few extra minutes?
Sure.
And I just wanted to apologize. I just realized that my Zoom functions have changed, and so my upvotes weren't showing in the order. So this one was a very popular question, which is why I really want to pose it. The Strata Council is not reporting all decisions. When asked by owners, they say that the decision was made between meetings. Is this allowed?
Yeah, complicated problem, right? And with COVID and with isolation, this is just perpetuated even more. We have a real chronic problem with it. The difficulty that council needs to step back on, and this is the question that every strata corporation needs to ask, whether you're the council, the property manager, or the owners. Where did we get the authority to act? And so if there was a decision about a repair, a decision about an emergency, a decision about an expense, where did we establish the authority to be able to conduct that activity? So it's either going to be a decision of council, a decision at a general meeting of the owners by some resolution, a provision within their bylaws, or a provision within the act. And if they can't provide evidence for that, then the Strata Council is going to have a really difficult time when somebody drags them into the tribunal. And that's where this really is going to be an issue. It's like bylaw enforcement. We've suddenly started imposing $50 a week of fines against someone because they have a pet. We have a no pet bylaw. They're not complying, and we're doing this. But there are no decisions within the minutes of the council meetings. These are decisions of council. They need to be minuted, they need to be documented, because the council at some point needs to show the evidence of where they got the authority to act on this. So when they're challenged, and they're challenged at a level of CRT, this could be very difficult for them.
Super. Thank you both so much. Thank you, everyone. Thank you, Tony. Thank you, Lisa. It's been a pleasure, and we look forward to seeing everybody again soon.
You bet. Thanks so much.
Thanks, Paula.
Thank you. Bye for now.